I've been practicing for a little over 7 years. I've been in estate planning since I graduated law school in 2017. Going into school, I knew this is what I wanted to do. And since being out of school, I started with the hanging the shingle. I had my own firm office and I kind of practiced door law, which you might hear here and there, which is basically anything that comes to the door. But I knew I wanted to focus on the estate planning. And I just had the envision to do this remote travel-based estate planning service because there's a lot of misinformation about estate planning, and then also it leads into an overpriced legal service with the way attorneys market it and the way that it's sold to the general public. So here we are. And then to answer your second question, estate planning is generally, a lot of people think of it as just death planning. What happens to my assets when I pass away? But that's not true. It more accurately would be called life planning, because the majority of the documents that you execute and implement into your plan serve you while you're alive. There's only a couple documents that serve you after you're gone. So I would say that any base estate plan would at least include your will, your power of attorney, a healthcare surrogate, and then a living will. And then depending on whether or not you're a business owner, some business succession planning. And then if you need control beyond the grave or have other situations that might necessitate a trust, then you implement some type of trust. But in a nutshell, life planning, estate planning.
Okay, so yeah, that's kind of what I was going to segue into. That's perfect. And the most common misconception that I hear as a notary is that you don't need estate planning until like you're towards the end of your life. What are your thoughts on that?
Every time I hear that, I say, what happens if you become incapacitated tomorrow and live another 40 years? Now, everyone thinks that, well, my mom or my spouse or someone will have control over me. Even a spouse does not have power over your finances and assets unless they have a power of attorney. So me and my wife married, if we didn't have a power of attorney, I become incapacitated and live another 50 years. She has no access to my assets. Nothing that she isn't already on, she does not have control over. Now, what would she have to do? File for guardianship. That means petitioning the court to declare me incapacitated and then petitioning the court to be declared my guardian. It's an expensive and time-consuming process that on average is $6,000 to $10,000 here in Florida, and then even emergency guardianship is about 30 days. So counter that, if I have a power of attorney and list my wife and then successors, that agent has all the authority to go do everything on my behalf while I'm alive. So there you have a $6,000 to $10,000 process or a $200 document. Now, there you go when it comes into why it serves you while you're alive. And the same thing with your healthcare surrogate designation, which sometimes you'll hear medical power of attorney. If you become incapacitated and you're in the hospital, who has the authority to make decisions on your behalf for your healthcare? Sometimes it's your spouse, but if you're not married, it isn't like someone else can say, we want to do this or they want that. It doesn't happen without documents in place. HIPAA controls and HIPAA limits these institutions on what they can do.
Yeah, and then with my background in banking, that's the same thing that would kind of happen with me, where I got to see some of the situations where a spouse would die and, it was very unfortunate, but the other person that wasn't on the account would come in trying to access funds. They weren't on the account and there was no type of beneficiary or anything like that. So usually I would just have to say, you're going to have to take this up with a lawyer or go to the courts and get all kinds of document, rather than if they would have just gotten it set up, everything would have been a lot more streamlined. So I completely agree with what you're saying, because that would happen all the time. It was so unfortunate. Yeah.
I have a bunch of horror stories with not
Yeah.
planning, both while
Yeah.
people are still alive and then after people pass away.
Yeah. So definitely, like, for anyone that's kind of on the fence, even if you are someone that is healthy and younger and whatever, I would definitely recommend getting an estate planning document together. And I don't know why, but nobody really likes talking about estate planning except for like estate planning lawyers
Me?
and notaries. Yeah, yeah, because we see it too. We see it on the other end where, these people are kind of, we get the emergency calls into hospitals where they have to do everything. And it's like super stressful for the notaries in general, like to have to kind of have that emotional weight. So yeah, definitely the more proactive approach would be to do everything beforehand, which goes into my next question is, can the general public handle estate planning without a lawyer? And do you recommend that?
This always is the standard attorney answer. It depends. Now,
Yeah.
I will tell you, I have met people that have done their research, all the legwork, and they come out and they have a plan that's not too bad. But
Mhm.
then I've had people that come to me and they have something that they purchased online. There's a couple, let's say, nationally famous people that have plans that you can purchase for X amount of money, which is typically very high. And then basically you just input your information and fill it out. If you get one of those plans, typically you don't have someone there actually talking to you like, hey, if you select this, this happens. If you select that, that happens. And then also when it comes into the formality. So to give you one example, I had a client come to me in Collier County and his mother had passed away. Now, his mother only had two children, him and his sister. His sister has been estranged for about 25 years, meaning she had no relationship with her brother or the mother. The mother, on her deathbed, printed out a form that she got offline and filled it out thinking it was her will. Well, unfortunately, that form that she got online had the signature at the top of the page. The court did not accept her will because it wasn't executed with the formalities, meaning her signature wasn't at the end of it, along with a couple other things.
Mhm.
So, guess what happens? Instead of that will saying half of it goes or all of it goes to my son, instead she had to follow her estate followed the intestacy laws. Her son took half, and her estranged daughter, she had no relationship for 25 years, took half. And the only asset in the estate was the home. So now the son that had been living with his mother for I don't know how long it had been has to give up half of his house to his sister, his estranged sister, or buy her out. And there's no way to get around that. You can't say, well, she meant to do this. An invalid document is an invalid document. And you can't come after the fact and say, well, they meant to do this. It's just like if the lottery numbers come out and I say, well, I meant those numbers. I'm going to go back and change it. It
Yeah.
doesn't happen.
So I read somewhere, like I don't really deal with the semantics of it, but I read somewhere that if you get the document notarized versus if you have it by two witnesses in the state of Florida, it makes it a little bit easier to get around some probate, or is that true or no?
No, so in order to execute your will and for it to be valid, it just has to be witnessed by two disinterested people. So
Okay.
I sign my will, two people sign it, my will's valid. Now, what you're referring to when the notary and two witnesses is called a self-proof affidavit, which
Hmm.
essentially is all the parties, so the testator, the testatrix, meaning the person signing the will, and then the witnesses all get together in front of the notary and say, yep, this person signed this document with the intention that it's their will, and then that negates the need for the court, the probate court, to call in the witnesses to ask the questions like, is this their will? That's the only thing that comes in whenever you review whether or not a notary notarized the will. So you can have a valid will that's just witnessed by two people. It
Yeah.
will be accepted. But if you do the self-proof affidavit and have it notarized with the two witnesses, then it's accepted and you don't have to call those witnesses in the court.
Okay, so it's a way to cut down on time and basically
Mhm.
add more validity to whatever it is that they're notarizing, right?
It makes the dreaded process of probate just a little bit easier.
Okay, so to kind of move into marketing towards estate planning lawyers, because I think the majority of the people on here are notaries that are interested in getting into this industry. How would they market to you, or like how do people usually market to you as a estate planning attorney?
The proper way or the improper way? You want both.
I guess. Well, now I didn't know, but yeah, both now. I want to know.
Yeah. Well, I'll tell you that being hassled by someone that wants to do business can be aggravating. I
Yeah.
mean, if I tell you I don't have time right now or sometime in the future, that's the first thing because a lot of times the people that I choose not to work with are the ones that won't, pardon my language, but shut up. It's like let me be, come back later. It is what it is. But the person that just stays there and keeps on it, it's like, all right, well, I'm not going to work with that person. If you're this annoying, you're probably going to be that annoying with other clients. That'd be the negative way. Don't, if they say hold on or not interested, take them at their word for it. Leave them alone. But if they show interest, follow what they're telling you. So if they say, yeah, reach out in a week or reach out in a month or hey, time next week, that's how you get in with them. And then to add to that, there's plenty of people that are trying to reach out and get people's business remotely and just with an email or just with maybe a phone call. If you have the opportunity to go meet these people in person at a social networking event or something like that, it's a whole lot easier for me to say, yep, I'm going to use that person because I've met them, I like them. Or at the same time, it could be I met them, I don't like them, but it could be the negative side. But you're better off meeting these people. If you have the ability to meet them at a social engagement, some type of networking, that's the easiest way. Now, depending on whether or not you just go to their office, that's a gambit because sometimes their days are pretty structured and scheduled. So if you just try to come in there, you're probably going to get the same thing. Hey, look, he's busy right now. And then you may or may not be able to make an appointment or leave your information. That's always a personal decision up to whoever's trying to gain that business.
All right, so we went over both ways because that kind of threw me for a loop as far as. But that's funny though, because I know that you say that, but sometimes I have people or clients now that have been like, I'm never gonna use you, like,
Yeah.
stop trying. And then like a week or two later, they're like, hey, Katie, I said that I was, yeah. So
Yeah.
I mean, it's back and forth where sometimes they're just like, absolutely not, and then I'll just leave my information. Um, and then, send occasional notes or anything. But usually if I get like a hard stop, I won't go visit their office anymore,
No.
like, yeah. So when there is someone that is kind of as a notary marketing towards estate planning, what's like the pain points that you guys have to deal with that would make you use mobile or remote notaries instead of just like
Um,
an in-house or an in-house client notary?
So if I have to send it to a remote notary or a remote online notary, I'm giving them specific instructions. This is exactly how I want you to execute these documents with the client or clients. And this is the exact way I want you to go. This is the exact order I want you to do it. As long as they follow them, great, I'm good. It's whenever they go in there and shoot from the hip and just kind of jump around, that's where it could cause issues and pain points with other attorneys.
Hmm. Yeah, that's why I like working with attorneys so much is that there's no guesswork
Yeah.
when it comes to the documents of filling out everything because it's very much like that's something that we were going to go over, but for the documents, everything is laid out. So sometimes there's initials that need to be on the bottom, like right hand
Hmm.
side of every single part of, the will, or there's parts where it needs to have the social security number filled out. But for the majority of any of the estate planning lawyers or just lawyers in general, I love working with you guys because you'll give me like a breakdown of like, make sure that the initial on each page, make sure that this
Hmm.
is filled out on page 52. And then like sometimes I'll even have people call me and go over the entire document before we have the actual notarization itself. But that is something really, really nice for anyone that's listening. If you're trying to go over any of the documents, try and find a will or like something within that state of Florida so that way you can kind of go over it beforehand in case an estate planning lawyer calls you and is like, hey, do you know how to fill out or do these types of notarizations? Usually what I'll do if I have a document that I don't know is I'll just Google it and then kind of look it over just so that I know what I'm looking at before I get the actual document sent. I just Google everything before stuff's sent. Yeah, ChatGPT and Google are usually my favorite things to use. How has remote online notarization kind of impacted your business?
That depends on the client, but I will say generally positive
Yeah.
because one thing that positive that COVID did do for us was release us from the workplace. So now we can all commit to this remote work, which I absolutely love. Now,
Hmm.
that's not for everyone. There are some clients that know you got to be in person with them, but majority of people kind of got used to Zoom and virtual calling during COVID. So now it's a whole lot easier to do that. And then with the implementation of Ron here in Florida, I mean, I try to send a lot of documents to be done remotely with remote online notarization, just because it's not something that I kind of hold near and dear, where in the sense I have to be with this document and guide the client through it as they execute it, like a
Hmm.
deed. I don't need to sit there and walk them through it. That's something I can easily go over with before. And hey, you're transferring the interest into your trust to this person, so on and so forth. This is how the deed works. It's not a document like a power of attorney where I sit there and walk them through all the elections that they could make. So the
Hmm.
document like a deed is easy for me to send. Hey, Katie, can you execute this with this client? And then the other benefit of that is when you get a Ron, like Katie, and I'm sure plenty of you others are also here, you send in the document, is like, look, this is the client. And then they reach out, like Katie reaches out to the client, hey, when do you want to do this? Like that makes life a whole lot easier for me, because then it's all right, all I got to do is send it and then wait to get the executed document back that I can then submit for recording.
Yeah.
But generally positive with the Ron.
That's what I've noticed too. And you have an interesting business model too, which I kind of wanted to highlight. And I don't know, I've never met another lawyer that does this, but you'll go around to the different locations of like to meet with your clients, correct?
Yep. So I got this idea about a year and a half ago, and I kind of like sat on it and let it fester a little bit. And the biggest thing is one, with all the misinformation about estate planning, everyone either thinks it's only for the rich, or I only got to do it when I'm getting ready to die because it only covers my assets. First part of that, I only have to do estate planning if you're rich. The only thing that is alluding to is tax planning, which means if your estate, when you pass, if you're an individual, is about $6.5 million or more, and if you're married, $13.6 million, that's whenever you could get an estate tax after you're gone. If you're nowhere near that, your estate plan is not going to be complicated. I mean, you might have a distribution schedule that's a little out there, but for the most part, everyone should have an estate plan, regardless of whether or not you have $100 in your bank account or you have $10 million in your bank account. So the first thing is, okay, I want more people to have an estate plan. How do I go about this? All right, let's try to make it more convenient for people. How do we make it more convenient for people? By this time, we had already been through COVID. We already seen all the things you can do remotely now. They started doing all the real estate closings remotely, not just with a remote travel notary, but a remote online notary. It's like, well, if you can do all that, why can't you do your estate plan also remotely? And it just kind of went, okay, this is one way to offer more people services, estate planning services, but also not be stuck in an office. I don't want to be stuck in an office day in, day out. I don't want to work a traditional 9 to 5. Yeah, my schedule is 8 to 8, but if I want to block off the middle of the day to go do something with my children, I block off the middle of the day to go do something with my children. It isn't like I'm stuck in an office somewhere. And I absolutely love it. Like, it's coming up on a year now I've been doing this, and I should have did it as soon as I got out of law school, but then COVID hadn't happened, so I would have had to been in office.
Okay, so we're getting some questions. Monique said, do you prefer to work with a notary that you know, or do you prefer to use a big company like Notarized Proof who will provide a notary in a snap, but you won't know how they work?
I want to know the notary. I'm not just submitting it to a company. I'm going to know the person. I'm going to talk to the person. I'm going to give them instructions. I want to know exactly who it is. I don't want to just submit it to a company and let them run it through their system.
Yeah, and then Christina says, I've met EP. EP?
Mm-hmm.
What's
Estate planning.
oh.
Estate planning. I was
Okay.
being lazy.
No, attorneys in
Fuck
Orlando
you.
that won't go near not Ron. Sorry, I should have realized that. Have you, I mean, because you network with a lot of other estate planning attorneys too. Have you run into that a lot? Like what did they say?
It really comes down to the attorney themselves, and you have to think that my practice model is very untraditional. So that's why my slogan is not your grandfather's attorney. I'm not making you come in and sit down in my office with the high billable hours. I'm trying to make this modern. I'm trying to make it convenient and easy. Now you go to the attorney that is old school, came up the old way, been practicing their entire practice the old way. They're not going to jump on this Ron. Think about all the other new, let's say, technologies that have come to make life easier. How long does it take for everyone to get on the boat? Even things that we all end up getting on. Like, I can remember when these virtual meetings, when they first started, you had plenty of people, I'm not doing that. I'm not doing Zoom. I'm not doing any other ones. And now look at us. Now it's second nature. We're all doing it.
And then Isabel says, do you need a lawyer to make a trust?
Again, it depends. Depends on the person. I will tell you that I would not recommend it, but at the same time, that I have met people that have never been to law school, but they're very intelligent. They can go and read statutes. They can go and read probate rules and everything else to figure out exactly how to do it. So again, it depends on the person. I wouldn't recommend it. I really wouldn't, but it depends.
Yeah, and then like to say to your fact as far as like using an estate planning attorney, there's stuff that the normal person, well, at least in my case, when I was, setting some stuff up, there's a lot of stuff that you would not think about that an estate planning attorney can bring up automatically, like, okay, you have a minor child. Well, what happens when they go to college, or what happens when they do this? Do you want certain things for them? And that's not something that you would be able to really find on any of the DIYs. It's just basically like, okay, this happens and there's no provisions, and if something happens, that's just how it is.
Yeah, I'd like to speak to that.
Yeah, of
So you
course.
think about, especially if we're just focusing on trust there, I think the best benefit of using an attorney is they're going to be able to tell you what's possible with a trust. So you might be able to execute a trust and it be valid and it work the way you want to, but you might have missed a lot or left a lot on the table that you could have implemented in the trust plan based on someone that knows, hey, you can do this with a trust, you can do that with a trust, you can set it up this way, you can separate, you can divide it. I mean, trusts are amazing vehicles, but again, not everyone needs one of them. I'll tell you right now, you can take this. There's only two reasons why someone would need a trust. One, they have assets that they cannot turn into non-probate assets without a trust. And two, they want control beyond the grave. Those are the only two reasons why anyone would need a trust. I get that conversation. I have that conversation all the time with potential clients, because in the 90s and early 2000s, you had these people going around giving seminars. Everyone needs a revocable living trust. Not true. Unless you fall underneath those two and your answer to those first two questions, you have probate assets that you can't turn into non-probate assets without a trust, or you have needs that require control beyond the grave, which you can only get by doing a trust-based plan. If you don't have those, you don't need a trust-based plan. And that's one of the things that would answer that is like, do you need an attorney for a trust? Well, first of all, do you know if you really need a trust or not?
And then Kimberly asked, do you have a RON platform that you prefer your notaries use?
I think it might be me not being familiar enough with all the different platforms, but as long as my documents are executed right and come back the right way, I don't care what the notary does with them. Now, if they come back right, but the client says, I hated that, that was the worst situation I've ever been through, then I might say, hey, what did you use? What's the problem with it? And then go from there. Because I have had one where the people couldn't get the recognition, they couldn't get all that
Knowledge-based
through. And
authentication. Yeah.
yeah, and they're like, the client was like, don't ever do that. We're not doing that again. And they were really mad at me. And I was like, I'm sorry. I'm really sorry. I'll have
Yeah.
it taken care of. But
Yeah.
other than that, as long as it works right and it isn't a hassle for the clients, I could care less.
Yeah. So obviously, since you're remote too, basically, if someone wanted to contact you directly to talk about some of these things, do they have to be they have to be in the state of Florida?
I
Or
only do planning for Florida residents.
okay.
I
Okay.
get that question a lot too.
Yeah.
I'm not barred in any other states, and I have no intention of being barred in any other states.
Okay. Okay. That makes sense. I never know, but that is amazing as far as a use case, because then that opens up your market to the entire state of Florida when you're doing this remotely. And especially for the notarizations, because then you don't even have to have them go anywhere to do the whole entire planning.
Yeah.
Yeah.
And not
So
even all of my plans are done remotely. I would say probably 70 to 80% of my plans, I travel to the client to do the execution. I only a small percentage of it will I send them to a RON to execute their
yeah,
documents.
yeah. Does anyone have any other questions? Like if you wanted to unmute and ask the question, or just put it in the chat and I can just ask him, but does anyone have any other questions?
I have some tidbits to pass along.
Okay, yeah.
I would start with, let's go into the deeds, because I'm going to assume that's a lot of your practice is deed work, I
Yeah.
would guess.
Mm-hmm.
Okay, so when you ask about the DIY documents, I swear that's the easiest DIY document. Yeah. I swear I get more of those and more issues out of those than anything else. I think it's because it's so easy for people to go on there and they think it's quick claim deed,
Yeah.
which is not quick claim deed, it's quick claim deed. But
Yeah.
I see that all the time, and the people are like, yeah, this is the form. And they fill it out and then they use the brief legal description that's on the county property appraiser's website. It specifically says on every property appraiser's website that I've been to, do not use this for legal documents. People choose to do it anyways. I have done no less than 11 probate estates in Florida just for a piece of property that the decedent used one of those documents that they printed out, and it's not accepted by the clerk and the property appraisers just because they used the brief legal description. So when you talk about DIY documents, if you are seeing these documents and a client's like, hey, I got this form, I just need you to notarize it, you might, I guess, get some brownie points there. You say, is that a brief legal description? Did you get that from the property appraiser's website? Doesn't work. I know
Well,
you can't give legal advice.
I know, I was
but
about to say,
that's
Matt.
also not legal advice. It says right there on the property appraiser's website, do not use this for legal documents. So then you can just ask them question, is this a legal document? The website says don't use it, but no less than 11 estates where the person tried to transfer it before they passed, and then it's not accepted, and they have to get notice because the clerk sends out a notice, hey, look, this is an incorrect deed. You got to file a corrective deed. And they don't do it, and then they pass away, and the family's like, why isn't the property in my name? She did this deed. Well, it's inaccurate document. It's not accepted.
Okay, so then we have some other questions. One is, I'm a single mom. I have one son. Should I have a trust or just a living will?
I don't want to get into specifics on here. I will tell you that one depends on the age of your child and what you want to do and how much control you want to have after you're gone. And just to kind of go into the estate planning talk here, if you do a will-based plan, meaning your plan for post-death is governed by a will, as soon as the distributions are made after probate, your beneficiary or beneficiaries get everything all at once, whether it's $5,000 or $5 million. A trust-based plan gives you control beyond the grave, where you can say, one, we already avoided probate, but one, you can say, look, they get the money whenever they turn 25 or 30, or when they get married, or if they're in school, I want to incorporate the HEM standard, which is health, education, maintenance, and support. That's the only really thing that you got to think about when it comes to a trust. And then with children, there's a lot of other questions that need to be asked. So what about this? What about that? And it goes back to, can you do a trust on your own? I would tell you or without an attorney. That's where attorney benefits comes in there, because they're going to ask you questions that are going to make you think. Like, oh, wait, I didn't even think about that. And a lot of times I have to play devil's advocate with clients. And it's like, look, I know you're not thinking about this, but you have to think about this because that is a possible scenario. And you want to cover every possible scenario with an estate plan. And some people are like, well, that's never going to happen. Okay, it's never going to happen. But what if it does?
That's a perfect example, because especially with us as notaries, and then just in the space that we're in, we see worst case scenarios. Legitimately, I mean, for me at least, almost the majority of the time is the worst case. Like, things have gone terribly wrong, and then we're kind of left with the mess, and then all of the survivors of also have to have those tough conversations and those tough decisions, because someone didn't always necessarily make the best plans. Definitely would try and get everything set up beforehand. Another person asked, so Kimberly asked, are the documents you prepare, assuming living will, HIPAA, healthcare surrogate, POA, last will, etc., accepted everywhere they are if signed via Ron? I've heard some banks push for a wet signature on their own in-house power of attorney form.
That's a fun one. That's a very fun one. So I'll start with the power of attorney, because that's a very specific document that has specific rules. And one of the rules is that if it is valid underneath the Florida statutes, all third parties must accept it. And if they don't accept it, they are liable for the cost of enforcing that they accept it. So one, and banks are typically the worst ones, and one of them that rhymes with BOA might be the absolute worst bank. They say they want this, but if your power of attorney is valid, it's executed validly, they have to accept it. If they don't accept it, what's the remedy if someone doesn't do something you want to, or something that they're supposed to? You got to take them to court. The benefit is underneath the power of attorney statutes, it specifically says, look, if this is a valid document and you don't accept it, you're liable for the cost of enforcing you to accept it. So in that case, the bank says, we don't want to accept that form. We want you to do this form. They can't require that. If they keep sticking to it, then you sue them. You got to accept this, and then they're liable for the damages. So the rest of the documents, there's kind of a smorgasbord of them for the living wills, the healthcare surrogates. But for the most part, as long as they follow the statutes and it's pretty clear on what they're trying to do, medical institutions are kind of, every one of them is different, just like a bank. But I haven't had any problems with them accepting the documents, because most of these forms, which you're not really going to hear that often, are basically just templates, or they're provided to us directly in the statutes. Like, look, the statute says use this form. Guess what? The best way to abide by the law is to use the form that the law tells you to use. So I would tell you that I haven't had any issues with it. The power of attorney has a nice little remedy there, but the other documents, as long as they're in line with the gist of it, they're going to be accepted.
Okay. I didn't know that, because I have been out of banking since, I don't know, a couple of years. So when I was in banking, we didn't really have a ton of remote online notarizations.
Yeah. And to continue with that, the power of attorney that I use, on the first page in big bold letters, it says right there, like, look, if you don't accept this, you're going to be liable for this. We're coming to do that, and so on and so forth.
Huh.
Because it's required. The law says if this is a valid document, you got to accept it.
So, okay, my next question is, I guess if it's for the banks, the thing that we keep running into is for the loan signing, the underwriters and the lenders don't accept run signatures. I mean, do you have any thoughts on that as far as?
Well, see, here comes into the fun part, is whenever you do those documents, those mortgage documents, loan documents, those are their documents. So they can tell you they want it done with a wet signature. They can tell you they want it done in person. Now, does all of them require it? No, some of them are ahead of the 8 ball, just like some attorneys and notaries are ahead of the 8 ball when it comes to what's possible. But at the same time, if mortgage company A says they want you to execute their mortgage in person with a wet ink, you have to do it. You can't say, well, I want to do it remotely. What are they going to tell you? Well, you're not getting a mortgage. Okay,
Yeah.
that's simple. But banks can't require you to use their form.
Okay, interesting.
For power of attorney. For mortgage, they can.
Okay.
But wouldn't the statute technically trump that?
For what?
To an extent, like kind of like what Katie's stating is, when like our underwriters or escrow officers or banks try to use like their mortgage forms, but in the statutes, it states that certain documents to an extent can be signed remotely. Wouldn't that statute kind of, in a sense, override that? Or is it more because it's the bank's form, they can basically push, like you're stating, like, hey, this XYZ document needs to be signed in person with a wet signature, et cetera, et cetera.
Yeah. So the first thing I'll tell you is I don't practice anything real estate. So when it comes to the mortgage laws, I'm not going to tell you what is the law in Florida, what is not the law. But typically those statutes say can be done. It can be done. You can do this. You can execute them remotely with an online notary. But that doesn't mean you have to do it that way. So that kind of gives these mortgage companies the ability to say, okay, we'll do it, or no, we're not going to do it. We want you to do it this way. And the same thing goes with outside of power of attorney. When it comes to dealing with financial institutions, they have their own processes. I mean, you go to any financial institution, they might all be generally along the same lines, but for the most part, each and every one of them has their own process and system, how they want you to do things. And you have to follow it if you want to work with them. It's just that simple.
And then on that note, just in general, this has nothing to do, this is not legal advice, this is just kind of bank advice. When you do have the power of attorney and everything like that and beneficiaries, make sure that you're letting your bankers know that, so that way they can get the accounts set up the way that you would want to have them set up as a individual. So like, let's say you add a power of attorney, or you add a death beneficiary, make sure that you're letting the banks know that too, so that way they can get it set up on the back end, because usually the documents have to be submitted into legal in order for it to reflect on the banking side. Because otherwise, like, let's say you have something set up like a will or a trust, unless you let the bank know, there's going to be a process that they have to go through. Like we have, like when I was a banker, or like when I was in banking, you had to submit it. And so sometimes what would end up happening is the other partner or the other person would submit the documents, but then bills were still coming out of the account, but that person couldn't access it. So if they would have just had everything kind of set up beforehand, it would have made everybody's life a lot easier. So submit the documents to the banks as well for when you get everything like the estate planning trust set up. Like that's,
Yeah.
I mean, that's what you would kind of say too, right, Matt?
Yeah, no. So in Florida, we don't have a register of wills, and your estate planning documents are not public documents. They stay private. Your will become public in the event that probate's needed. But other than that, all your documents stay private. Now, when it comes to providing documents to your bank or financial institution, I would caution you to think about it. So one example is a lot of times they'll tell you they need your trust. They don't need your trust. They don't have to know everything in your trust. You can give them an affidavit of trust, which will suffice, and every financial institution has to take it. Continuing with that point, just because in your trust says so and so is a beneficiary of something doesn't make it actually happen. You actually have to go to that asset, to that financial institution, and list your beneficiaries. So, like
Yeah.
Katie was just saying, you have to get them to list your beneficiaries. And I will tell you that the bane of my clients' existence whenever they go to actually implement their plan is dealing with the financial institutions. Some of them are really easy to deal with. Some of them are very difficult to deal with. If you want to add a beneficiary to your account, never let a bank tell you we can't do that. Now, they can be limited when it comes to a business account because typically you can't list a beneficiary on those types of accounts. But an individual account, a joint account with you and your spouse, you and a friend, you can list beneficiaries on there. And most institutions, if you push back enough, will let you do a hierarchy. You can list a primary beneficiary, a secondary beneficiary, tertiary beneficiary, which basically goes through the list. If one isn't around, it goes to two. If two isn't around, it goes to three. But they don't make it easy for you. Financial institutions are difficult to deal with.
Yeah, that's basically what I meant. I don't know if I got my point across pretty
No, I
well, but
gotcha.
you did a better job than I did. So do we have any other questions? I know that we're kind of running over the time frame. So I think we're gonna wrap it up here, but I just wanted to thank you. And then, so how do people contact you? How do we find you?
Right to the website, hblwt.com. I have the QR code right there that has my information. And then I've made it easy to submit an inquiry. You go to the website, request a call, complete a simple form. And like we were talking about, all you taking advantage of Ron, there are other technologies out there that help make business easier and more affordable. You submit that form, you're going to get put into the system, get a call, get another form, depending on what you choose, and go from there.
All right. Well, thank you guys so much. I appreciate everybody for coming on. Matt, thank you for your time and to
Absolutely.
share your knowledge. So thank you guys.
Thank you, everyone. Have a good weekend.
You too.